Today was another momentous day in international justice news. Ratko Mladic's life sentence has been upheld this afternoon, while the Cour de Cassation, France's highest court, held hearings in the Lafarge case, where a French company and some of its executives are alleged to have been complicit in crimes against humanity committed by the Islamic State in Syria. International courts, national jurisdictions going after national actors, both are important pieces in the wider accountability puzzle. What we will discuss today is the third important element, certainly gaining in traction and importance, namely universal jurisdiction. Good morning, good afternoon, or good evening, everybody. My name is Philip Grant. I'm the Executive Director of Trial International, and it is my immense pleasure to be hosting this webinar with our colleagues and friends from the Center for Justice and Accountability in the USA, Redress in the United Kingdom, the European Center for Constitutional and Human Rights in Germany, the International Federation for Human Rights in France, and Civitas Maxima in Switzerland. Before we kick off with our panelists, please note that this event is recorded. And at the end of the discussion, we will set aside probably around 20-25 minutes for a Q&A session with the panelists. In that respect, please use the chat and Q&A functions to submit any questions or comments you may have, and actually whenever you want. You should also receive, after leaving the event, a very short survey. It's only 2 questions that will allow us to understand whether you might like similar or more focused webinars on specific countries or issues in relation to universal jurisdiction in the future. So thank you for your feedback. Universal jurisdiction has seen so many recent developments that I am sure we'll all enjoy a lively and hugely interesting discussion with some of the leading actors in this field. I now pass the mic to Carmen from CJA in San Francisco to moderate the event and wish you a nice evening.
Thank you so much, Philip, and thank you to all of you for being here. I'm Carmen Cheung, the Executive Director of the Center for Justice and Accountability. Again, thank you to our friends at Trial for organizing this conversation today across so many time zones. Like my colleagues on this webinar, we at CJA work to seek truth, justice, and redress for the most serious of human rights abuses. We investigate abuses, we work with communities impacted by atrocity, and we all find avenues for legal redress under the principle of universal jurisdiction. I just wanted to take a little bit of time to sketch out what is universal jurisdiction. I see on the participant list that there are many familiar names and faces, and so some of this may be already very well known to all of you, but just quite briefly, so what is universal jurisdiction? International law recognizes that certain crimes are so serious that the duty to prosecute them transcends all borders. These crimes, such as war crimes, crimes against humanity, genocide, and torture, they are such grave breaches of international law and custom that they constitute crimes against all people. And accordingly, all nations should have the authority and the duty to hold perpetrators of such crimes accountable, regardless of where the crime was committed or where the perpetrator is found. And it's under this principle of universal jurisdiction that we are seeing crimes arising from the Syrian civil war being prosecuted in Germany and Sweden, and a criminal complaint relating to the genocide of the Rohingya in Myanmar filed in Argentina. Universal jurisdiction can take many forms, depending on the domestic implementing legislation. While some form of universal jurisdiction exists in at least 147 countries, the scope of its reach can vary quite significantly across states, whether it's because of the implementing legislation itself or the prosecutorial priorities for each state. Some of our colleagues on this call have done some really important work recently around setting out what the legislation for various jurisdictions looks like. For example, our friends at the Open Society Justice Initiative have put out some really informative backgrounders along with Trial on universal jurisdiction in certain selected states. And so in the United States, where we work, for example, we have criminal statutes that reach some, but not all, of the conduct that is typically captured by universal jurisdiction. For example, we have a War Crimes Act and laws criminalizing genocide, but we have no similar prohibition on crimes against humanity. However, one unique feature of the US system is the availability of civil remedies for international crimes, which CJA uses to litigate a form of civil universal jurisdiction on behalf of individual plaintiffs. These cases cannot result in criminal penalties such as prison sentences, but they do provide the basis for developing a judicially determined record of atrocity. My colleagues here today will spend the first part of our discussion describing how universal jurisdiction works in 4 different states: Switzerland, Germany, France, and the UK. They will also describe the dynamics of the war crimes units in their respective jurisdictions and provide insight from the perspective of organizations that specialize in developing and bringing forward cases under universal jurisdiction. This year's Universal Jurisdiction Annual Review, which was published by Trial and our organizations here, shows the scope and the range of universal jurisdiction cases across the globe. In 2020, 18 new cases went to trial, bringing the total of active universal jurisdiction proceedings to 30. But the relative strength of universal jurisdiction has varied across states. And so in our discussion today, I hope my colleagues will be able to share their views on how universal jurisdiction has advanced or not in their respective countries. You will see biographies for all of our speakers in the chat, so I will not go through everyone's extensive histories and backgrounds here. Instead, please let me turn the floor first over to Emmanuelle Marchand from Civitas Maxima to start off our first round of comments. Emmanuelle, over to you.
Good afternoon, everybody. I'm very pleased to be here with you. I would like to thank Try International to organize this event. Because of time constraint, I will not go through the history of the UG in Switzerland. I will just discuss the current landscape, which was shaped by the law of 2010 in Switzerland, which entered into force in 2011. So thanks to this law, you can build UG cases in Switzerland for genocide, crimes against humanity, and war crimes. And what is important is that this law really, for the first time, include crimes against humanity into the criminal code. It also transfers the jurisdiction of those crimes to the civil justice system before they were tried by the military system. What is also important to note is that after the adoption of this law, and thanks to the hard advocacy work of NGO, including Trial International, a specific war crime unit was created within the jurisdiction of the federal public prosecutor. So in order to build UJ cases in Switzerland, you have a few conditions. One of them is the presence of the suspect in Switzerland. And this is very interesting, especially when you will hear from my colleagues, because on paper, this could make like Switzerland, like a country, very reactive in terms of UJ. You don't need other additional conditions like residence, you really need just the presence. So it doesn't matter if the person fled after, leave the country, and even if you look at the case law, there is a broader interpretation of this word where you can, Switzerland can open an investigation even if the person is not present yet on the territory, but if there is like strong indication that the person would come. And of course, there is also a condition of subsidiarity, like you need to make sure that the suspect is not tried in another jurisdiction, or if make sure that no other international courts are competent, and make sure that there is no extradition pending. I just want to have a few words regarding the work of the war crime unit, because like I think like for years, like, and if you look also at the trial work, like this is something that NGO, we know we are really advocating for the creation of those special units with special talent people dedicated to building those cases. So there was a lot of expectation when this unit was created, I think, and it was really perceived when it happened like as an achievement for the civil society and for the legal practitioner. But if you compare the achievement of this unit, like now, years after this creation, compared to the other unit maybe in Europe, and as you will see, you can perceive and see like really that there is a need for improvement. I think what is the most obvious is that after 9 years of creation, there is only one case that has been brought to trial, and it's the Agio Koshia case. And I will discuss this case later on. And actually also this trial also happened 6 years after the arrest of the suspect. So this is also something that we have to take into consideration. And when you wonder what is this situation of in Switzerland, the people working within the unit, you had former federal prosecutor who spoke about the lack of means and resources of these war crime units, which make it really also difficult to conduct those crimes, which require usually lots of resources because there are investigations abroad, witnesses coming from different places. So if you want this unit to be efficient, you need to give them resources. And this is also the word of the former general prosecutor who was saying also that his team was overstretched. And sadly, since September 2020, we have to know that there is no longer any general prosecutor in Switzerland. We're still waiting for someone to be nominated. So, so if we compare the Swiss war crime unit to the other, we can say that maybe if they would like to be up to speed, more resources need to be allocated to this unit. Thank you.
Thank you so much, Emmanuelle. Let me turn things over to Yaroslavna from ECCHR.
Thank you very much for having me on. Thank you for the organization of this webinar. So I'm going to cover Germany, and next year it will be 20 years since Germany adopted its Code for Crimes Against International Law, providing for universal jurisdiction over war crimes, crimes against humanity, and genocide. This means that investigations and prosecutions of those crimes can be initiated in Germany, even if committed outside the country, regardless of the nationality of the victim or the perpetrator. And to do so, Germany has established specialized units within its police and prosecution services, and investigations are led by the General Public Prosecutor. Over the last years, a number of investigations were initiated by the prosecutor and have resulted in significant proceedings. So this year, we welcome the worldwide first conviction relating to systematic torture in Syrian detention facilities as crimes against humanity. It was a case of A@A. And the thereto related trial against Anwar R. is still ongoing in Koblenz. He is charged with being complicit in torture of at least 4,000 people, among other crimes. We also witnessed the trial against an Iraqi national and former ISIS member, Taha al-J, for crimes against Yazidi in Iraq. So this trial can lead to the first conviction for genocide against Yazidi. These are significant steps towards accountability. These trials manifest the role that universal jurisdiction can and should play in tackling impunity and enabling survivors and witnesses to testify. However, it cannot go and should not go unnoticed that these accountability efforts so far have been quite one-sided. We do not see arrest warrants for crimes committed in Syria by Turkey or Russia. And also beyond the Syria-Iraq context, we see cases regarding crimes committed in Gambia and Afghanistan at the moment, but we do not see investigations against any powerful actor resulting in similar steps. And this shows a continuation of double standards policy in universal jurisdiction. So while we push for politically more challenging cases, it is crucial to demand that the ongoing proceedings that we have are conducted holistically and also with a strong gender perspective, so that they can serve as a solid blueprint for future proceedings. So far, there was no conviction on crimes of sexual violence and gender-based persecution under the German universal jurisdiction law. So now the German prosecutor and the courts actually have a chance to advance in this regard. For example, in the trial against Anwar R, the Syrian systematic torture case, where the incidents of sexual violence have been indicted as acts of crime against humanity. Similarly, also in the genocide-related trial against Taha al-J, lawyers filed a motion demanding recognition of gender-based persecution of Yazidi women as part of the charges. And gender perspective should also be equally applied to the crimes committed against LGBTQ in the Chechen Republic of Russia. With our recent complaint, we demanded an investigation not only into the crimes of torture, but also into persecution on gender grounds, because this would bring recognition of the gendered motive of the perpetrators. So if the prosecution and the courts would give these crimes full consideration, it would be a much needed step towards recognition of sexual violence and gender-based persecution as international crimes at the domestic level. And it would also follow the developments that we see before the International Criminal Court. So to sum up, Germany definitely has made significant steps in advancing universal jurisdiction, and it has proven that it has the legal framework, it has capacities and the expertise to do so, yet these efforts cannot be limited to politically comfortable cases only, and we are yet to see the equal accountability steps against powerful actors. Thank you.
Thank you very much for those comments. Let me turn things over to Clémence over at FIDH.
Hello, everyone. Thank you, Carmen, and thank you, Trial International, for hosting this event and inviting us to participate. I will briefly look at the situation of universal jurisdiction in France through the lens of its war crimes unit, to talk a little bit about the dynamics in place and the evolution of the situation since the last decade. The French War Crimes Unit was created in December 2011 and is effective since January 2012. It has a national competence on international crimes, torture, and forced disappearance, genocide, crimes against humanity, and war crimes, and is solely dedicated to the investigation and prosecution of these crimes. The fear at the time when it was created was that it would serve the exclusive purpose of dealing with the cases related to the Rwandan genocide of 1994, because a lot of these cases were stuck within the ordinary French judiciary, and that it would not have the necessary means to fulfill wider ambitions. The first years of the unit, we can say that it was a lot about struggling for resources and for sustainability, a struggle that was led both by the unit itself, but also by the civil society groups, including a lot of organizations on this panel, advocating for the consolidation and the effectiveness of the unit. A second major institutional evolution happened in March 2019, where the prosecutor's office of the War Crimes Unit was merged with the anti-terrorism prosecutor's office within a national prosecutor's office in charge both of anti-terrorism related offenses, but also of international crimes. And at that time, there was also fear among civil society groups that what could be considered as an anti-terrorism priority would absorb the resources of the international crimes component of the prosecutor's office. We can say that this did not happen, hopefully, and that nearly 10 years after the creation of the War Crimes Unit, the situation has positively evolved and that strong dynamics are now in place. First of all, the War Crimes Unit is comprised of 3 investigative judges, 5 prosecutors assisted with specialized assistants, and a body of investigation comprised of a little bit more than 20 investigators. Of course, we will never say that is enough resources given the number of cases that are dealt with by the War Crimes Unit, and also the strong expectations I think there is from victims in seeing this unit being consolidated. But we can say that there is a growing trend in supporting the War Crimes Unit and its resources. And I think we can also say that the War Crimes Unit now has fulfilled the challenge of sustainability within the French judiciary. As of January of this year, there were about 150 judicial investigations, both judicial and preliminary investigations that are being dealt with by the War Crimes Unit. And the situations have largely extended from the initial majority of cases that concerned the Rwandan genocide of 1994. It covers now a whole diversity of situations going from Asia, Africa, Middle East and North Africa, but also Eastern Europe. And Syria and Iraq have become the situations, I think last year or a couple of years ago, with the highest number of cases that are being investigated. So before now, the 1994 genocide of Tutsis in Rwanda. There were 3 arrests made by the War Crimes Unit last year concerning suspects from Syria, DRC, and Central African Republic. And a majority of the cases now arise from asylum applications that have been rejected and that are automatically deferred from asylum authorities to the French War Crimes Unit, which poses specific challenges in relation to victims' participation, as these cases do not follow complaints from victims, but are initiated by the prosecutors themselves. One word of conclusion to maybe highlight a few negative aspects of the trends and evolutions now. Only 2 trials for the moment. The length of the proceedings, as a lot of investigations have been going for a long time now, and I'll come back to that when I'll refer to one specific case, more than 10 years for some investigations. And the framework and legislation, which remains very restrictive since the law enacting the Rome Statute in 2010, and that provides still for very restrictive criteria for universal jurisdiction for ICC crimes in France. Thank you.
Thank you very much for that. And finally, over to Charlie at Redress.
Thanks, Carmen. In the UK, responsibility for international crimes investigations lies with the War Crimes team. That's a subset of SU15, which is a unit within the Metropolitan Police that's also responsible for counter-terror investigations. The prosecutions are carried out by the Counter-Terrorism Division within the Crown Prosecution Service. We're fortunate to have attendees from both the UK Police and the prosecutor in the audience today. In terms of the legislation, torture, war crimes, crimes against humanity, and genocide can all be prosecuted in the UK using universal jurisdiction under the Criminal Justice Act and the International Criminal Court Act. The last decade has been challenging for universal jurisdiction prosecutions in the UK. The last successful conviction in the UK was in 2005 with the Zardad case. He was an Afghan warlord. Since then, the Lama case involving a Nepalese colonel resulted in an acquittal in 2016, and the case against Agnes Taylor for torture during the First Liberian Civil War was dismissed in 2019. We shouldn't see the failures of the Taylor and the Lama cases as detracting from the efforts that the UK authorities have made to prosecute international crimes. Both of those cases required significant amounts of time and expense on the part of the police and the prosecutor in the UK. And they were both unsuccessful for quite different and in some ways unusual reasons. The Lama case was beset by problems with finding suitable interpreters, and it was undermined by inconsistencies in the evidence, part of which was gathered by NGOs. The Taylor case had an important win at the UK Supreme Court. It confirmed that non-state actors could commit torture under the definition in the UN Convention Against Torture. But unfortunately, the case failed on the facts because the prosecution was not able to show that Taylor's armed group had sufficient control of the territory at the time the torture was committed. There are, though, promising signs for the future of universal jurisdiction prosecutions in the UK. The police have a very large ongoing investigation into 5 Rwandan genocide suspects. There have also been 2 other arrests in the last year. One arrest in August 2020 of an individual for war crimes during the First and Second Liberian Civil Wars. And there was also an arrest in May 2021 of another individual for war crimes during the Sierra Leone Civil War. There are other structural reasons for optimism. We're seeing greater coordination and knowledge sharing by the UK's War Crimes Unit with other war crimes units in Europe. The Genocide Network, organised by Eurojust, should take a large amount of credit for that. We're also seeing greater cooperation between the UK Police and the UK's border agency on evidence gathering. That builds on some of the practices that we've seen from other countries, such as Germany. So the overall assessment for the UK is one of cautious optimism and hope for a resurgence in the next couple of years. Thanks, Carmen.
Thanks very much, Charlie, and thanks to everybody for your very insightful, informative comments. So against this structural and political backdrop, what has been the reality of universal jurisdiction? I see a number of universal jurisdiction litigators in the audience as well. And so I suspect they may have comments from their own experience, which we'd really be appreciative of hearing from in the Q&A. And of course, the Universal Jurisdiction Annual Review aims to round up current cases and developments in UJ. So I would encourage everyone who hasn't taken a look already to review that if you haven't had the chance and if you're interested. For now, I'd like to invite my colleagues to spend a few minutes each highlighting a particularly illustrative example of a universal jurisdiction litigation. Emmanuelle, would you like to start off this round again?
Hello. Thank you. I would like to discuss quickly the Kosia case. The only case I went to trial in with the Federal Criminal Court in Switzerland. So Kosia was former commander during the Liberia Civil War, and as an NGO, we filed a complaint in July 2014, and the authorities were quite reactive because they really act and arrested Kosia in November. So we saw that the case was really moving like at very fast speed at the beginning. But the reality is that because of the means and the resources, Switzerland firstly only conducted an investigation in Switzerland with people who were refugees there. And the results were not so important. So they, of course, tried to have cooperation from Liberian authority. And at the moment, they didn't get the authorization. So we have to, as NGO, to actually do our investigation and bring the victim to Switzerland. And it was also very strange because it's also, we're speaking about 2015, it's Ebola time in Liberia, and we had to develop our own quarantine system to make sure that we are not the NGO who brought this tropical disease in Europe. So this was one of the constraints. And in addition, in the middle of the proceeding in 2015, the prosecutor was dismissed. So we had a new prosecutor, which asked also for more delay in the proceedings. And even if we heard like during the investigation stage, like the last witness, I think in 2018, the trial was only set up in 2020. So in 2018, Kosia was indicted, but then COVID happened, so the trial was postponed again and again and again. And finally, in December, we had the trial, and the first part of the trial in December 2020, and the last part of the trial was the beginning of this year. And we are actually expecting a verdict on the 18th June, so in 10 days from now. So really finger crossed for for Liberia case. If I have to do an assessment of the case, what I would say is that if we think about the right of the accused, there is an issue here because like it's more than 6 years that this person was in pre-trial detention. And I think if you compare to other systems, like in Belgium, I think you have 3 years maximum. But it's interesting to see that this war crime unit didn't consider doing an investigation in third country, which happened in other instances. But Switzerland was really reactive for us. Like we had one of the plaintiffs told us like a few days before traveling to Switzerland for the trial that she was pregnant. She said she was 6 months pregnant. We found out she was 9 months pregnant. So she could not travel, of course. So in just a few days, the Swiss authorities was really able to arrange video link to make sure that the plaintiffs were able to participate in the trial, that the victims were represented. So as I would say, like we still like really perceive that as the first case, so still as a success now. But if you look at it along the way, we will have in terms of timing, it's for sure that we will have appreciate that the proceeding would be move a little bit faster. But this should be seen in the context of now, as I said before, the war crime unit with all those changes, the prosecutor being dismissed, some people not being there. So we hope that in the future, yes, the war crime unit will be reinforced. Thank you.
Thank you very much. Yaroslavna?
Thank you. I would like to say a few words on the trial in Germany concerning the systematic torture in Syria. So the German prosecutors started to investigate crimes by the Syrian regime almost 10 years ago. So since then, criminal complaints and evidence on systematic torture have been filed to the prosecutor's office by Syrian and international NGOs, including ourselves. And last year, a trial started against 2 former Syrian intelligence officers who were arrested in Germany. And in February this year, we welcomed the first verdict regarding the systematic torture as a crime against humanity in the first case of Ayad A, and the related trial against Anwar R is expected to finish by the end of the year. And in this trial, ECCHR cooperates with lawyers who represent 15 joint plaintiffs. So why is this trial significant? First of all, it provided many survivors and witnesses with an opportunity to testify before the court, which is an essential part of any accountability process. It provided space for establishing the truth about what happened. So there were more than 70 days so far on which the court heard evidence, not only from survivors, but also from activists and experts, and therewith honored the tireless efforts of the Syrian and international civil society that documented these crimes over so many years. The court also tested a variety of evidence in this proceeding. So it should be noted that this very trial relies on unprecedented evidence. So we had Caesar images, original documents from state authorities, testimonies of defectors, and surely not every case can provide a similar evidentiary base, but this trial showed what kind of evidence can be relied on in such proceedings. And we hope that the results of this trial will lay the foundation for future cases regarding crimes of the Syrian regime, be it in Germany or elsewhere. And these trials can also serve as a blueprint for future domestic proceedings addressing similar international crimes of such scale. Because from the practical point of view, the court had now a chance to consider a variety of issues relating to such, trials. The court had to pay attention to the security of survivors and witnesses who testified. It granted psychosocial support when needed. However, what remains critical with regard to this trial is the lack of information in Arabic regarding such proceedings, and also the lack of Arabic interpretation for public audience in the courtroom. Because so far it was only granted for a few accredited journalists who are speaking Arabic. So the authorities should recognize that when conducting such trials, providing access to information is absolutely crucial to ensure that correct information on the trial is accessible, and it can be reported widely about such trials also in Arabic. So to wrap up, we see that German authorities have proven that they can successfully investigate and prosecute such crimes, and now we expect them to apply this gained expertise also in other cases that we filed over the last years, including US torture program, torture in Chechnya, war crimes in Gaza, and other cases. Thank you.
Thank you very much. Clémence.
Yes, thank you, Carmen. If you allow me, I'll talk briefly, not about a successful case, but one where we have been struggling in France, and it concerns a French company. Although it concerns a French company, I have to mention that it has been filed and accepted on the basis of universal jurisdiction provisions. The name of the company is Amesis, and we filed a complaint back in November 2011, so nearly 10 years ago, against this company for having sold surveillance material to the Gaddafi regime at the time. The case has been ongoing for 10 years now, the investigation, the judicial investigation, creating a lot of frustration, and rightly so, among the victims. I think that this case is an example where strong evidence has been collected by the judges, also through the testimony and active participation of the victims who have shared their stories, but also filed themselves evidence of having been arrested, subjected to torture, following the surveillance that they had been subjected to by the Libyan security services, thanks to this material sold by the Amesis company. And it is also an example where a case that has progressed despite the lack of collaboration and cooperation from the territorial state. And I think that it's important to underline that in a majority still of cases open under universal jurisdiction, judges have to be innovative in the way to gather evidence because they do not have access to the territorial state or no cooperation from the state where the crimes have been perpetrated. So despite this evidence, the case is still ongoing. As I said, in 2017, the company has been placed under the status of assisted witness, which is kind of an intermediary status before a formal indictment for complicity in torture. We thought that it was a positive sign at the time, but we're now in 2021 and still waiting for new and positive developments in the case. And we feel that again, this creates a lot of frustration among the victims who are Libyan victims, 6 who are participating as civil parties and have been doing so since the beginning of the case. And I think also that it shows, and in this I would join what my colleague said from ECCHR, the kind of double standards, and we face major obstacles when we try to challenge corporate complicity and maybe powerful suspects also that do not come from situations where it is politically easy to prosecute. So we hope that there will be positive developments. Philip has talked during his introduction about the Lafarge case, and we're still waiting also for a decision that will serve certainly as a precedent in terms of seeking corporate accountability for complicity in international crimes before the French judiciary. But we really hope that we'll manage to get also positive developments in this Amesis case.
Many thanks, Clémence. And Charlie, over to you.
Thanks, Carmen. I'm going to talk about what we refer to as the Rwanda 5 case. This case involves 5 individuals who are suspected of involvement in the 1994 genocide in Rwanda. They're all alleged to have been mayors or local politicians and to have been responsible for various incidents, such as ordering attacks, organizing roadblocks, and providing weapons. They've all been living in the UK for a number of years. 4 of them were arrested by the UK police as far back as 2006. That was following a request by the Rwandan government to extradite them back to Rwanda for trial. Extensive court proceedings followed in the UK, which culminated in a decision in July 2017 by the High Court of England and Wales. It found that they could not be extradited back to Rwanda because they could not be guaranteed a fair trial there. As a result, the Rwandan government asked the UK to investigate and prosecute the suspects. The UK police confirmed in April 2019 that an investigation was ongoing, and UK government ministers have since confirmed that the police have travelled to Rwanda to undertake investigations on the ground. The most recent public information is that 4 of the suspects were voluntarily questioned by the police in September 2020, and we understand the investigations are still ongoing. I'm focusing on this case because it's a critical test for the UK after the difficulties in the Lama and the Taylor cases. It's an opportunity for the UK system to show that it can still prosecute universal jurisdiction cases, but there are challenges. Just the scale of the investigation is daunting. These are 5 different cases, as we understand it, involving 5 separate sets of incidents. There's also likely to be a huge amount of evidence that already exists, which needs to be reviewed from the ICTR, the ECCHR trials, and potentially from other universal jurisdiction prosecutions. So it's not an easy task, but I think it's one that we should all be keeping an eye on to see whether the UK is able to play its part in combating impunity.
Thank you very much, Charlie. And so I think I'm handing things over to Valérie now. I think you're still muted, though.
Thank you very much, Carmen. And thank you very much to all of you. It was very, very great to hear all your experiences on universal jurisdiction cases. I think we've learned quite a lot on all your cases and the context you're working on. And we will continue to do so in the second part of the webinar with the questions. So you can already start to ask your question in the chat box. You already started to do it. Thank you very much, and we'll answer them later on. And so before starting with the question, I would like to review briefly some of the points raised by our great panelists. In the discussion of today, we presented the disparities between states. disparities when it comes to prosecute international crimes such as torture, war crimes, crimes against humanity, genocide. We can also have a look to our Universal Jurisdiction Annual Review, the UJR. It also addresses all those disparities. And those disparities concern primarily the requirements to use universal jurisdiction. In some countries, as it was exposed today, those requirements are very narrow, probably too narrow, as you explained, Clémence. For example, in France, the conditions are very strict. And as a consequence, there only have been 2 cases up to now. In some other states like Germany, for example, the conditions are very large. And for example, in Germany in 2020, there have been numerous universal jurisdiction trials. You can find them on the UJR. The disparity in the political will and legal framework is one thing. It is very important, and this disparity impacts the number of cases. We see them with few in France, many in Germany. But actually leading a proper universal jurisdiction investigation is the biggest challenge. Clémence explained a bit why, and Charlie too. First, the crime scene is abroad, so it's very hard to get there and to investigate and to have the consent of the state, the territorial state. The case depends also a lot on witness and victim testimonies, as sometimes you can't go on the crime scene. And witnesses and victims are often abroad and hard to reach. And maybe Emmanuelle can share a bit later her experience on the Liberian case from Civitas Maxima. The scale of the crime also, Charlie from REDRESS also mentioned the scale of the trial for the 5 Rwandan case in the UK, but the scale of mass atrocities for national prosecutors, it's complicated to deal with. All these challenges were identified in the past in previous UJR, but this year in 2020, they were multiplied tenfold with the COVID-19. As you know, with the national lockdowns, movement restriction, quarantine, well, then how to reach the crime scene? But even in normal context is hard. Then when you have national lockdown, you just can't. And how to reach witnesses, victims? In the end, how to conduct an investigation? You can see, like with the COVID-19, investigation on universal jurisdiction cases were nearly impossible. And the number of new investigation in 2020 speaks for itself. It really has dropped. I'm speaking only of the new investigation, because we should not forget one thing. Actually, our panelists show it today, and our universal report that I should actually show you here, and you can find it online. It has shown that actually cases have moved forward in 2020. It was mentioned earlier by Carmen, there had been 30 accused on trial in 2020. And more than 144 suspects have been investigated. And this is only the tip of the iceberg, because they are not all named, so we don't know exactly the number. And great steps were made in 2020. The panelists, you explained it, but I'm just gonna summarize quickly. Yaroslavna from the ECCHR presented the Al-Khatib trial. The Al-Khatib trial will make history. It's the first trial of a Syrian high command, and a trial addressing sexual violence. We hope it will be successful, and we all hope this will be the first of a long series of trials like this. In France, we understood with the FIDH, with Clémence, that investigations are very slow. But there are many investigations ongoing. And let's hope those investigations will become soon new trials. We know that the Liberian Contike should go on trial for torture. You can find it in the report, page 40. And several trials on the genocide in Rwanda will also open in the next 2 years, such as the Atejikimana trial or the Muyamana trial that you can also find on the report. So these are very interesting trials to follow in France. Well, in Switzerland, as you mentioned, Emmanuelle, from Civitas Maxima, it's quite a poor record. Almost 10 years and only one case of universal jurisdiction. But let's hope the Kojia case will bring a new dynamic. And of course, now we expect to see the Omar Sonko trial to open soon. And with the Trial International litigation team, we will keep you updated on the trial and how it's going. You can also find it in the report. And as for the UK, Charlie, you addressed the setbacks with the Kumar Lamar, the Agnès Taylor cases for various reasons, but indeed, it was very disappointing for all of us, for all of the actors of universal jurisdiction. But the future does look brighter, and we will follow the trial of the 5 Rwandans for genocide in 2021. And we'll also follow the cases of the Liberian and Sierra Leone suspects that were arrested this year and last year in the country. Well, finally, in the US, we are looking for the forward for the Michael Song Korea trial that you can also have a look on the report. To conclude, all these cases exposed by our panelists prove that actually the judicial community can adapt and can develop creative way to investigate, and it has to, because today it's a pandemic, tomorrow is going to be something else, and actually many countries we can't even go anyway. So the COVID-19 doesn't change the fact that you can go on the crime scene or not. So it's good to have to see that the judicial community has really taken off. And this is thanks to all the efforts and progresses that were made in the last years. And it shows also that the trials can go on if you have a good political will and also human and financial resources. And I leave now the virtual floor to Philippe before we start with the question. Thank you.
Thank you, Valérie. I think everybody mentioned the issue of the passing of time as being one of importance. The first ever universal jurisdiction verdict in Switzerland against a Rwandan genocidaire was rendered in the year 2000. In 10 days, we'll have the second verdict in the Liberian case Emmanuelle presented. 21 years have passed between those two verdicts. In the meanwhile, quite a lot, and at the same time, as we have heard today, way too little happened. Here in Switzerland, in the other states discussed today, as well as in numerous other countries. What is clear is that in order for these cases to move ahead, a number of prerequisites must be met. A solid legal framework must be in place, laying out the relevant offenses and offering in particular to the accused a fair trial that will legitimize both the process and the verdict, whatever the outcome. That will, however, not be sufficient. Specialized war crimes units must be set up, endowed with adequate resources, and strategies drawn up to make sure the cases investigated can be brought to court. That, however, will not be sufficient. Courageous victims, sometimes ready to take immense risks as they step forward, need to be empowered and given a leading role in the process. That, however, will not be sufficient. NGOs with the capacity to investigate, to file complaints, and or to support and represent victims and victims' organizations are also fundamental. NGOs have been present at some point or the other in the vast majority of cases successfully brought to court or currently being investigated. NGOs have located perpetrators, have investigated crime scenes, have brought back evidence and testimonies, have supported victims and victims groups, have appealed and litigated cases, have undertaken important advocacy or communication work. If we are to continue to see positive trends in the future, and I'd just like to take the example of the upcoming Iranian trial in Sweden planned for August, universal jurisdiction cases will have to stop being perceived as extraordinary and slowly start to become normal, albeit complex cases. I take the opportunity of having such great organizations around the table today to stress the need for each of us to continue our cooperation, not only on specific cases, but also in imagining what the future might hold. there is a pressing need to look ahead at ways to better structure the international universal jurisdiction movement, including and in particular in countries where there are no civil society actors present. There is a pressing need to widen the circle of lawyers and organizations able to participate in such investigations and trials, and to empower victims and victims groups. There is a pressing need to engage with academic actors, with forensic experts, with artificial intelligence specialists, with donors, with journalists, and of course, with prosecuting authorities in our countries and beyond. We have now passed the point when universal jurisdiction was still being questioned as a viable legal concept. Was it or was it not? We can and we should begin with all the concerned stakeholders, start to plan today the strategies that will allow universal jurisdiction to go mainstream tomorrow. Back to you, Valérie.
Thank you very much, Philippe. And so I see that we have many questions on the chat. Thank you very much for this. I see that the debate is very interesting for all of you. So the first question is for Yaroslavna. The first question is about the political influence and difference in Germany. And if the person was wondering if you still see the presence of political influence and difference to foreign policy. The reference is being meant to the Rumsfeld case, of course, and in comparison with the Syrian investigation nowadays. So what's your opinion on this?
Thank you very much for the great question. As I already said, I think the double standard is quite evident. Just if we compare, let's say, the US context and the Syria context. A few years back, we also filed a complaint against Gina Haspel, who is now the head of CIA, for the crimes that were for torture in Thailand back 2 decades ago. And at the same time, we submitted the complaint against Jamil Hassan, who headed the Syrian intelligence service at that time. We saw an arrest warrant against Jamil Hassan, and unfortunately for US torture program and different black site detentions, we still haven't seen anything. And the same double standards we see even in the European context. So torture being committed in Russia is not investigated, while in Belarus, for example, now we already see some beginnings where the prosecutor has reportedly started some preliminary examination. So you can see, depending on how powerful the actor is and depending on where the foreign policy goes at the moment, you definitely see parallels. I don't want to say there are clear connections, but you definitely see the parallels being reflected in how cases are being handled.
And then maybe to all the panelists, do you see this also happening in the context you're working on? This influence, political influence? Maybe Clémence, you can start for France.
Well, again, I also don't see any precise connections, but parallels that have to be drawn and that I think we can all witness from all the cases that we have tried to litigate or that others have tried to litigate. And we witnessed the attempts from colleagues from the Palestinian Center for Human Rights at the time to file complaints all around Europe against Israeli suspects of war crimes. And when we see that all these attempts have failed, the attempts in Spain also against Chinese suspects, etc., when it's all about raising the possibility of complaint and responsibility of those that are powerful. And we see also the important setbacks that we have witnessed, the modifications in the laws, the legislation being amended. We have seen this in France also, when investigative judges who are independent in France tried to press charges or even summon a Moroccan official, and that it led to a change of legislation and a change of the bilateral treaty between Morocco and France that exempts now any Moroccan suspects from being prosecuted under universal jurisdiction in France. So I mean, yeah, I do feel that examples talk for themselves, and that we have all again witnessed that kind of things happening, and that kind of major obstacles being raised in the way when it's about challenging the accountability for those coming from powerful states or powerful entities. And this is why I was referring also to the obstacles that we are facing in corporate complicity cases.
Thank you very much, Clémence. And it's also something we've seen in Spain with the Tibetan case, and then the law that was changed in Spain because of the political influence. Maybe Charlie, your thought on this?
Yeah, I would echo Clémence's points. We saw in the UK, after some attempted prosecutions of Israeli officials using private prosecutions, the law on private prosecutions was changed in the UK to make it harder for private prosecutions to be brought before judges in universal jurisdiction cases. So similarly, we've seen changes to laws used to make some of these cases harder in the UK and for political reasons.
Mm. Mm. And Emmanuelle, I know that in Switzerland, Switzerland have been, well, finger on Switzerland for the lack of independence of by the UN. So what's your thought on this?
I think maybe for the attendees, maybe the point of it would be like, maybe I will leave the floor to Philippe. I think he has a broader, like, also historical and battle regarding that, and I think he may have more element of answer on that.
Philippe, the floor is yours.
Yeah, I'll pass that question. I was focusing on something else.
Sorry, I was
trying to prepare some other answers.
So the influence, the political influence in Switzerland that was showed by like the UN denounced the fact that there were a lack of independence. So what's your thought on that?
I mean, basically like in most other countries, the separation between the political sphere and the digital one is one that is guaranteed in law. Now, what happens behind the scenes might be a different story. And I think what is the most important factor is how prosecutors censure themselves when there are complicated cases, when possibly for their career it might be challenging to go after powerful actors. I don't think there's a direct influence. We haven't seen that playing out very clearly, but the system does not guarantee yet that prosecutors can really act in a completely independent ways, including by having the means to carry out their investigations. There are numerous ways to stop investigations, and working on the purse is of course one of them.
Thank you. So I'll go on to the next question on the role of the open source intelligence evidence, what role it has played in the trial, the ongoing trial. So maybe Emmanuelle, you had some thoughts on this, maybe on the Liberian cases?
Yeah, but just like, as I said, regarding digital evidence, like Liberia is also like we are speaking about cold cases, like we are speaking about crimes that were committed a long time ago. So in terms of documentation, we have not a lot of digital evidence. But what we use also this kind of investigation for is for the tracking of suspects and the localization of perpetrators, their displacement, and this is basically what we use. Like it's not maybe nowadays, like for the current context, you have a lot of digital, of course, evidence with a lot of YouTube videos, things that are going on. But in our actual cases where we are working on Civitas, they are old cases. So you don't have most of evidence are witness evidence, but we use digital investigation for localization of perpetrators.
Carmen, I see that you approve. Do you have any thought on the question?
Well, so I think I would tend to agree with Emmanuelle here that I think the open source investigation continues to play a really important role in generating leads, in moving us towards the right direction, in identifying witnesses, potential perpetrators, that sort of thing. I see further on in the Q&A that Beth Van Skalk also has a question about the role of AI and big data. in this work. And I think that a lot of that probably hasn't reached the evidentiary stage in these cases, so much as it has perhaps played a bigger role in analysis, and particularly in the Syrian context and the processing of information, that we've seen the attempts to develop better technological resources in order to sift through just the sheer volume of open source information that's available about the conflict.
Thank you very much, Carmen. Next question is for Clémence. It relates to corporate responsibilities and the challenges, the key challenges facing the trials of corporate actors. And the question asks, does it relate to human rights due diligence duties being still in their emergence?
Yeah, I think there's a whole set of reasons, and we could organize a whole webinar on this issue, in fact, but a whole set of reasons that constitute obstacles in pursuing corporate accountability through the complicity angle. First of all, I think it's difficult. There's still a difficulty to apprehend the corporate complicity with the traditional framework of complicity and the legal provisions that are available. Also reluctance, as we said, because we're facing powerful actors, and this, I think, also contributes to the resistance that we can see. And I think that the Lafarge setback and very recent example is a perfect example of what happened, where the Court of Appeal annulled and canceled the indictment of the company for complicity to crimes against humanity, just stating and adding a new criteria, I would say, for corporate complicity, which is not only knowledge, but also the sharing of intention. And if this is confirmed in July by the Supreme Court, I mean, this is a level and a threshold that will never be met, because we never, at least in our cases, assume that the corporations were sharing the intent to commit the crimes. There are have the intent of making money and doing so in the knowledge that they can contribute or may contribute to the perpetration of international crimes. So that there is, I think, still a very strong, again, legal resistance also, and difficulty to apprehend this corporate complicity. And of course, yes, the fact that the due diligence is in progression, but still at the beginning, is also very much a strong obstacle.
Thank you very much. And the next question relates to the recent initiative to conclude a multilateral legal assistance agreement for international crime at the European level. Do you think it's likely, and what do you think about it? So I see Emmanuelle wants to talk.
Yeah, I think we're following this initiative closely, because I think it's really important, and this is what we were discussing, like the difficulty to do investigation in those cases. And it's so easy for the country or the crime war committee to just do nothing, but just not answering a request for cooperation and just block a whole case because of that. So it's true that it's important that to have a treaty regarding mutual legal assistance that will facilitate the exchange of information and make things easier, to have like intermediaries, person identifying each country to deal with requests related to those international crimes, will make the investigation easier. And also it's important also for civil society to follow this initiative, because there is also importance that victim witnesses, people assisting in country, NGOs, or just like a human rights defender assisting those cases in country, are also properly protected. So I think for us it's important that this initiative exists. It will make, I think, the investigation more smooth, and if done properly, like at least we may have more results. But yes, of course, there is several things that need to still be discussed regarding this initiative.
Thank you very much. Anyone else on this initiative? Okay, so the next question is for Yaroslavna on the structural investigation in Germany. as it has been described as a way to overcome one of the problems of universal jurisdiction and the fact you mentioned earlier, the double standard, the fact it's only prosecuting low-cost defendants. Different scholars even said that these investigations are a new approach to the principle, describing it as a new complementary preparedness approach. What do you think about that?
Thank you for the question. I'm not familiar with this approach, so I struggle to comment on this question, to be honest. But
you could comment on the structural investigation and the double standard that you were mentioning briefly earlier. Maybe you can elaborate a bit on that.
So the structural investigations allow the German prosecutor basically to gather any kind of evidence without disclosing what the content of the investigation is. So, for example, there was a bigger investigation on Syria, let's say, or on another countries, where a lot of different evidence would flow in, and out of the structural investigation, person-specific investigations would be basically emerging, and these person-specific investigations would potentially lead to the trial. So if we bring, let's say, the double standards context into this procedure, it also matters how much effort the prosecutor put into building evidentiary base against concrete, let's say, suspects. So if they are interested to send a political message to the Syrian government and say, we have enough evidence now to send an arrest warrant, they have put enough effort to basically build the evidentiary base against the suspect. But it does not, unfortunately, happen for other contexts. Let's say they argue that there is not enough evidence and they unfortunately have the discretion to do so. So they do not start investigation in other contexts.
And maybe Clémence, you could also comment the structural investigation that is ongoing in France.
Yes, well, I think the structural investigation in France was largely inspired by the German one because it did not exist and nobody was relating to this preliminary investigation as a structural one. Concerning Syria, I mean, it was referred to as the Caesar investigation, coming from the referral from the Caesar report by the French Minister of Foreign Affairs in 2015 to the French judiciary. But it became, and it is now named, the structural investigation. And I think that, again, giving the restrictive criteria of universal jurisdiction in France, the big advantage of this kind of structural investigation is that it gives a framework to gather largely evidence and in a broad manner on the crimes, and then to be able to feed into existing prosecutions when jurisdiction is there and that there is a basis for jurisdiction in a given case. And so this structural investigation concerning crimes committed by all parties in Syria has really helped also to consolidate the judicial investigations that are and the existing prosecutions that target Syrian suspects now in France.
Thank you very much. For the next question, I think it's a very important one, especially to be followed next year with in Germany. It concerns the charges on sexual gender-based violence and why are there not so many cases of universal jurisdiction on this field, and do you have any explanation and your comment on this? So maybe Yaroslavna, with the German case, I think it's a good case to.
Yeah, happy to respond to this great question. I think it is kind of a twofold answer. So on the one hand, it's definitely the matter of expertise of the prosecutorial authorities. So when you are looking at a case, you might be able to identify the gendered, let's say, nature of a crime, and you might be able to also contextualize, let's say, the sexual violence. So in Germany, for example, for at least 1 year of the trial now, the sexual violence was identified as a case under the domestic law, so a sexual assault. Only recently it was indicted as an international crime or a part of a crime against humanity. So I think it's a matter of expertise that prosecutorial authorities and also the police need to develop in order to work and identify such cases in a better manner. But on the other hand, we also need to say that there must be a better conversation about the stigmatization around this topic. So if there are no safe spaces, if there are no support structures for the survivors of sexual and gender-based violence, no one is gonna stand up and speak up. So it is responsibility of us as a civil society, but also of the prosecutorial and also actually asylum authorities, who are the first ones to receive the testimony often of the people who are arriving in the country, to create safe space, be it, for example, a female translator or a translator of the same gender or of the gender as wished by the person, and psychosocial support. So there must be structures in place actually to enable people to feel safe enough to speak about this.
Emmanuelle?
Yeah, thank you. I just want to second Yolanda, and just to say, like, it's of course training. Like we all know that staff nationally in every country are not properly trained. But there is also, in addition to that, also the question of the legal framework, how the crimes also properly covered. Like sometimes, like we also, depending of the time of the offense, sometimes you can only prosecute certain crimes under torture, so you don't really have also the legal representation of the crimes, and I think also yes, it's also a mindset. Like also we saw that also a lot with sexual violence against male, where even in the fact people have tendency sometimes, because there is sexual violence used during torture, that they would qualify that as an act of torture rather than an act of sexual violence. So I really want to second what Yaroslavna said. Like it's really there is a need of education at all levels, like also in war crime unit in Europe, and about how to approach sexual violence, and also especially in those cases of refugee cases where you may have survivors coming from a very different context. And it takes a lot of understanding and preparation to properly be able to interview such a survivor. Thank you.
Thank you very much. So I just mentioning that there is only 5 minutes left for all the questions, so sorry, we won't be able to answer all of them. But the next one is for Carmen, from our colleague Benigni from OSGI. In reference to the Myanmar case in Argentina, how can your NGOs connect more to Latin American NGOs that build UG cases?
Thanks very much. And I suspect this is probably a question for all of us, though I was the one who mentioned the Myanmar case. So I mean, I think there's a number of ways we can do it. I think it just starts off with us doing that outreach. And I think here at CJA, we have had a long history of working in the Americas on building the types of UJ cases that our organization specializes in. But I think that there are a lot of opportunities to think about going in the other direction, I think, which is what Beani's question is really about. How do we utilize the universal jurisdiction laws that exist in the Americas to start bringing UJ cases there? I thought I saw possibly Tomas on this call, and I don't want to call him out on this, but you know, he was so instrumental in bringing that case in Argentina. And so in addition to the comments from my colleagues here, it may be, if it's possible, it might be useful to hear from him.
Of course, who wants to take the floor? Okay, so I'll go on to the next question then. It's a question to Charlie, and on the role of redress in the 5 Rwandan genocidaire cases. What was your role, legal representation or other roles, and on other probable UG cases, what were the role of redress?
Yeah, so in the Rwanda 5 case, I mean, this is the case that's been going on for, since 2006 in the UK. We've been conducting advocacy to put pressure on the UK government and to continue the investigation, and have been working with parliamentarians to make sure that the UK police have been getting the financial and political support that they need. At times, we've come close to bringing legal proceedings against the UK government to judicially review the slow pace of the proceedings, but looks like things are moving on now. In other cases, we've done work on forming a link between the trial taking place and the victims in the country where the crimes took place. We've, in a case in the Netherlands, we've made a film about the case and then taken that back and shown that to the community where the crimes took place. And we think that's an important role that NGOs can play in terms of bridging the gap between prosecutions and victims. But it can be difficult in the UK. It has very strict reporting restrictions, and often you can't report publicly what is going on in the proceedings for risk of prejudicing the eventual view of the jury. And so there can be some challenges. But we continue to work with the UK police in other cases on potential prosecutions and building evidence. And we have a couple of ongoing investigations with the War Crimes Unit in the UK at the moment.
Okay, thank you very much. And I think that will be our last question. It's on the role of it's for all of you actually, on the role of universal jurisdiction in transitional context, such as Syria, we've seen it, but on other contexts, do you think universal jurisdiction cases can have a role on this? Maybe Carmen, you want to start? Oh, sorry.
Oh, sorry, was someone? Okay. Absolutely, and I think that the comment I'd like to make about universal jurisdiction in transitional contexts is the importance of engaging impacted communities when we bring these cases. I think that universal jurisdiction, because of its nature, relies on us bringing these cases outside of the countries where these crimes took place. And so it is so much more important for us to ensure that impacted communities are part of the conversation around how international justice gets constructed, what accountability looks like, and what kind of accountability is meaningful to these communities, and to make them truly co-participants in how these cases get developed and brought.
Charlie?
I would absolutely second that point from Carmen, and say that we're doing a lot of work, for example, in the context of Sudan as very much a transitional state. And there's real appetite there from the local authorities for universal jurisdiction prosecutions for perpetrators who they know are outside Sudan and who are not going to be going back to Sudan. And that's from the highest levels of the Sudanese government. I think the other point that others have made in the past, and is an important one, is that often universal jurisdiction prosecutions can seem to give some impetus to domestic accountability processes in the countries where the crimes took place. And I know that Civitas Maxima have been doing lots of fantastic work, trying to build on their universal jurisdiction prosecutions in that respect.
Yeah, Emmanuelle, do you want to elaborate a bit on that? We know, Civitas Maxima has done a great work on this.
So I think Liberia is an example of the impact of UJ cases. I think really because we started to build UJ cases because there is no accountability mechanism in Liberia. There were no discussion about bringing justice for 2 civil wars in the country. So what we did is that what Carmen was saying, we try to make sure that when we have tried abroad about what happened in Liberia, that the affected community are informed, and there were a question about outreach. And it's important that you brought back what happened in those trials back to the community so they can own what is happening. Even if just a few, because of the nature of the UJ cases, you just have a few maybe witnesses who can go and be present for the trial. So we make sure that they are aware of what is going on. And by doing that, we realized by bringing back the UJ cases, we brought back the discussion about justice and accountability in Liberia. And they were always a will and then thirst for justice for the Liberian population, but they never saw an option, a possibility. The extraterritorial cases show them that something is possible. So now what happened is that Liberian population is pushing for the establishment of a war crime court in Liberia. And you have a bill that has been drafted for the establishment of the hybrid court. You have march, you have like a weekly discussion about justice for past crime and the fact that former warlords are now in position of power. So at some point it seems that really justice needed to be outside of Liberia to go back, the idea of just to go back in Liberia. And I think this is, one of the impact of extraterritorial cases.
Thank you very much, Emmanuelle. And then I leave the floor to Philippe to conclude this webinar.
Thank you, Valérie. First of all, a warm thank you to our panelists for the fascinating discussion that we had tonight. I'd like to thank the participants as well, and especially all those who put up some questions. There was so much to unpack there. Too many topics, too little time to address them all. But I'd just like to go over some of the questions that were either not addressed or just barely touched upon. And I think each of these could be the object of an independent webinar. Crimes against children or prosecution, we talked a little bit about that, of sexual and gender-based violence. How do we strategize these cases? The use of artificial intelligence, digital evidence. There were questions about specific countries, Myanmar, Nigeria, Mexico, India. How do we work on these cases? How do we reach out to the affected communities? But also some questions about the risk of universal jurisdiction, the lack of localization and of local ownership. And also, we mentioned it a little bit, the link between UJ and TJ, universal jurisdiction and transitional justice. The role and the functioning and the funding of war crimes units. How to reach out to local diasporas to maybe obtain information and testimonies. How to litigate against states when there is no political will. Is there a possibility to force some of them, and how and where? I mean, all of these topics could be independent webinars. I'm not promising anything, but I think we might at some point try to organize follow-up discussions. But until then, I think we have to close the day. Thank you to everybody. Please, really everyone, stay safe and goodbye.